Hello, and welcome to another video on competition law, videos where we try to visualize some of the core concepts of competition regulation. In this video, we will look into the as efficient competitor test as a tool to identify abusive exclusionary conduct, both the consideration behind the test as well as its practical scope. Firstly, we might ask ourselves, what is an abusive dominant position? The European Court of Justice has defined abuse not only as an objective concept relating to the behavior of an undertaking in a dominant position, but also narrowed it down to methods different from those which condition normal competition, that has the effect of hindering the maintenance of the degree of competition still existing in the market or the growth of that competition. However, this is not very operative, raising the issue of how to separate, for example, pro from anti-competitive price reductions, as we only want to stop the latter. Traditionally, EU competition law has relied on a number of formalistic tests that identified an abuse against the naked behavior rather than the effect. For many reasons, this is untenable, which is why economic consideration progressively has been incorporated. In economic theory and with respect to EU competition law, three main principles or variations thereof have been put forward, of which the as efficient competitor test has gained particular traction lately. This presentation will explain the above principles and describe to what extent they have been used in European competition law. In this process, we will rely on the different standards of cost detailed in a separate video. The consumer welfare test deems the investigated conduct exclusionary if it reduces competition without creating a sufficient improvement in performance to fully offset these potential adverse effects on prices and thereby prevent consumer harm. This approach has largely been adopted in the US, but requires a full inquiry into the welfare effects in each particular case, and it is for that reason it's very resource-consuming and prone for under-enforcement. The no economic sense test deems the investigated conduct exclusionary if it would make no economic sense for the defendant, but for its tendency to eliminate or reduce competition. While this test offers a greater extent of simplicity by only considering the intent of the conduct, it also has the tendency to yield false positives and false negatives. It could also be argued that intent should not matter, essentially as we don't want to penalize companies for pursuing a profit-maximizing strategy. As the as efficient competitor test deems the investigated conduct exclusionary if it is likely in the circumstances to exclude from the defendant's market an equally or more efficient competitor. The AEC test plays a prominent role in the Commission's guidance of 2009 on applying Article 102. In contrast with the intent-based approach in the no economic sense test, this test focuses on the effects of the conduct and relies on quantitative analysis. Further, it could function as a supplement to the traditional formalistic tests. The AEC test has been utilized in a number of epic cases, such as Intel, Deutsche Telekom, Post-Danmark 1, and Post-Danmark 2. It is important to stress that the AEC test is just one possible test. In practice, other tests may also be applied. Therefore, passing the AEC test does not provide a safe harbor for dominant companies, but gives an indication to a stronger or weaker extent, depending on the exact case, whether abuse is present. In 2005, the Commission launched an extensive 102 review, which resulted in the 2009 Article 102 notice. The notice comes close to endorsing the AEC test as a necessary condition for price-based exclusion, but the test itself does not constitute a sufficient condition for finding an abuse. The Article 102 notice outlines general and more specific principles. When it comes to the general principles, the Article 102 notice points out average avoidable costs and long-run average incremental costs as the relevant cost benchmarks. Pricing below AAC is generally considered to be a strong indication of foreclosing behavior that as an efficient competitor cannot serve the targeted consumers without incurring a loss. Pricing above the LRAIC is generally not considered to be capable of foreclosing an efficient competitor. Pricing in between the two cost benchmarks is more of a gray zone. Such pricing strategy indicates that the dominant undertaking is not recovering all the attributable fixed costs of producing the good or service in question, and that as an efficient competitor could be foreclosed from the market. When it comes to specific exclusionary pricing strategy, the Article 102 notice specifically mentions predatory pricing, where profit sacrifice and the AEC test is in focus, and conditional rebates, where the Commission proposes to calculate the effective price and to evaluate whether this price excludes as an efficient competitor. We have dealt with rebates in a separate video and will return to predatory pricing later. The Article 102 notice does not refer to the AEC principle in the context of the non-price-based abuse discussed. However, for margin squeeze, the Commission describes the practice as a pricing scheme, which does not allow as an efficient competitor to trade profitably on a lasting basis. We have now covered the AEC's test role and theoretical considerations. But how do we apply the test in practical competition law? Due to the AEC relying on cost benchmarks, it is of fundamental importance to understand what principles govern the choice of the appropriate cost benchmarks and which costs are relevant. Historically, the benchmarks used in the AXO case have been consistently applied by the EU courts. These benchmarks are average variable costs, or AVC, which constitute costs that vary directly with the output of the company, and average total costs, or ATC, which have AVC plus the average fixed cost, where fixed costs are costs that do not vary with the output of the company. Recall that the Article 102 notice of 2009 points out that AAC and LRAIC as the benchmarks that the Commission are likely to use. These are refined versions of AVC and ATC respectively, where AAC is the average of the costs that could have been avoided if the company had not produced a discrete amount of extra output, and LRAIC is the average of all the variable and fixed costs that a company incurs to produce a particular product. It is important to note that these benchmarks are not universally the only ones that may be applied. Other cost standards have been applied in specific cases, for example, post-Denmark. In the following slides, we will look into more detail of how these cost benchmarks are calculated, specifically how AVC, AAC, ATC, and how LRAC are calculated, and which considerations must be made when doing so. AAC is the average of the costs that could have been avoided if the company had not produced the amount allegedly the subject of abusive conduct. The challenge in estimating the AAC is to identify this discrete amount. The reason is twofold. Firstly, we need to identify all the relevant cost items to be able to identify the relevant costs, the numerator of the AAC. And secondly, we need to know how many units we shall divide the relevant costs with, i.e. the denominator. This is of particular importance when it comes to semi-fixed costs, which are costs that increase discretely when production pass certain thresholds. In other words, semi-fixed costs moves upwards in steps. To illustrate this, let's assume that a company currently has a machine that is capable of producing 1,000 units. This machine costs $10,000 to maintain a year. However, the demand has increased lately and reached to a level of 1,200 units. To accompany the increased demand, the company buys an additional machine, thereby doubling the capacity, but also doubling the maintenance costs to $20,000. Thus, in this particular example, producing anywhere between 1 and 1,000 units costs $10,000 in maintenance costs, and producing anywhere between 1,001 and 2,000 units costs $20,000, and so on. As such, the maintenance costs are semi-fixed. LRAIC is the average of all the variable and fixed costs that a company incurs to produce a particular product. Thus, in contrast to AAC, LRAIC includes all the additional costs that a company incurs to produce a specific product. AAC is therefore a subset of LRAIC as illustrated in the house. Hence, LRAIC includes the following: product-specific variable costs, product-specific fixed costs, and expansion of common costs, such as expansion of the HR department. But this is not true with common costs that are fixed. But what do we mean when we distinguish between variable and fixed costs? Variable costs are costs that vary directly with the quantities produced. Material costs are a typical example of variable costs, and could, for instance, be the aluminum used to produce a car or the paint used to paint a bike. Fixed costs, on the other hand, remain constant regardless of how much is produced and includes costs such as heating and running an IT department. The third cost term that is worth mentioning is the marginal costs. The marginal cost is the cost of producing one additional unit. In other words, it's the increase in the total cost as a result of increasing the production by one more unit. While the difference between fixed and variable costs seem very clear from these definitions, it is worth acknowledging that in practice it can be rather difficult to make such classification. All costs are variable in the long run. So the key factor in distinguishing between fixed and variable costs is time. Over how long a span should one consider the ability to avoid the costs in question? The longer the time span, the more the cost will be classified as variable, everything else being equal. Now, knowing how the different cost benchmarks differ, we will look into some specific cases and how the relevant costs have been calculated for these benchmarks. In the AXO case, AXO held a dominant position in the EEC organic peroxides market. The abuse was selective and below cost pricing. Pricing below AVC was regarded as an abusive behavior since a dominant undertaking has no interest in applying such prices except the aim of eliminating competitors to enable the undertaking to subsequently raise its prices. Pricing above AVC but below ATC was and is regarded as abusive as they are determined as a part of a plan of eliminating a competitor since prices can drive from the market's undertakings, which are perhaps as efficient as the dominant undertaking. In the AXO case, the variable costs included raw material, energy packing, and transport, whereas fixed costs included maintenance, warehousing, dispatching, and labor. Specifically, the labor costs are of particular interest in this case, since the Court of Justice analyzed whether labor cost, variable or fixed, and concluded that the labor costs were actually negatively correlated with output and therefore regarded as fixed costs. Thus, some kind of positive correlation between quantities produced and costs must exist for a cost to constitute a variable cost. By this analysis, the Court of Justice took a more economical approach to classification of costs, and this cost classification had a lot of similarities with the AAC cost benchmark. In the Intel case of 2009, it was found that Intel had abused its dominant position in x86 CPUs, where the abuse investigated was, among other things, rebates. In this particular case, the AEC benchmark was applied, and if an efficient competitor is forced to price below AAC, it means that the competitor is foreclosed because as the efficient competitor incurs losses by making incremental sales to consumers. Thus, in essence, the analysis examines whether Intel itself, in view of its own costs and the effect of the rebates, would be able to enter the market at a more limited scale without incurring losses. In principle, a correct measure of average avoidable cost should take into account the most profitable alternative use of the production input which Intel, or as an efficient competitor, uses to produce the units in question. If an employee dedicated to producing x86 CPUs can be redeployed to another type of production, for instance, chipsets or flash memory, it would not be correct to treat his salary as unavoidable. This is an important nuance to which costs should be taken into account when applying the AEC test that the Intel case added. In 2003, it has been found that Deutsche Telekom had abused its dominant position in the wholesale market in access services, the retail market in narrowband, and the retail market for broadband. The abuse was margin squeeze. If the wholesale charges are higher than the retail charges, there is a negative spread. In that case, there is a margin squeeze in any event, irrespective of the product-specific costs. If the wholesale charges are lower than the retail charges, there is a positive spread, which is a price squeeze if the spread is not sufficient to enable the historic operator to cover the product-specific costs of providing its services to end users, that is, below LRAIC. This case is an example of how detailed a categorization of costs can be when applying the AEC. The product-specific costs comprised only the cost of providing those additional services which are needed to give Deutsche Telekom and users access to broadband connections. To calculate the product-specific costs of providing the service, one had to do the following. Deduct the overhead costs, i.e. the cost of merely providing the network infrastructure, add the product-specific costs that would arise from any specific equipment required to provide analog ISDN and ASDL services from the DT's customer relations. Since analog needs extra equipment, the product-specific costs derive simply from customer relations services such as marketing, maintenance, and invoicing. And when it comes to ISDN and ADSL, specific equipment is required, and as such, these costs should be included. At this point, we have looked into the theoretical considerations behind the AEC test and the cost benchmarks which it, to a large extent, relies on. In the following slides, we will touch upon the scope of application of the AEC test. In the Post-Danmark 2 case, Post-Danmark offered rebates spanning from 2007 to 2008 to its direct mail customers, which contributed to the exit of the market of its rival, Bring City Mail. These rebates were retroactive over a one-year period, meaning that the prices were set at the start of the year based on estimated volumes and adjusted at the end of the year based on the actual volume of mail sent. The European Court of Justice considered the rebates to be different from quantity rebates since they were not granted with respect to individual orders, but on the basis of the aggregate orders placed over a given period. The rebates did not fall into the category of exclusivity rebates either, as they were not conditional on the customer obtaining all or a given proportion of their demand from the incumbent, Post-Danmark. Since the rebates did not fall into either category, the European Court of Justice held that it was necessary to consider all the circumstances. So, should the AEC test be applied in this case? The European Court of Justice considered it relevant that Post-Danmark had 95% of the market and that 70% of the market was uncontestable due to statutory monopoly. The ECJ also noted that the suction effect from the retroactive rebates was further enhanced by the fact that they applied across the contestable parts and the non-contestable parts of the market. Due to the statutory monopoly, Post-Danmark was an unavoidable trading partner, thus making it even more attractive for consumers to purchase all of their requirements from Post-Danmark to obtain larger discounts. Considering these factors, it would have been a rather small step to apply the AEC test. Assume a consumer has total purchases of $100 at full price. 30% of purchases are contestable. A 16% discount equals $16, attributing the entire discount to the contestable part of the market, which the as efficient competitor test does means the effective price in that part is $14 compared to the price without a discount of $30. That is a discount of 53.3%. The next step in the as efficient competitor test would then be to compare this effective price of $14 with AEC or LRAIC of the service. If the effective price is lower than the cost, the as efficient competitor test is failed and the rebate is considered anti-competitive. However, with reference to the fact that the statutory monopoly applied to 70% of mail on the relevant market, the ECJ stated that applying the as efficient competitor test is of no relevance inasmuch as the structure of the market makes the emergence of an as efficient competitor practically impossible. The ECJ did not disregard the AEC test for rebate cases altogether, but considered it as one tool among others for the purposes of assessing whether there is an abuse. In another case, Intel offered exclusivity rebates and naked restrictions, which the Commission deemed to be abuse. Firstly, Intel awarded 4 OEMs rebates on the condition that they should purchase all or almost all of their demand from Intel. Secondly, Intel awarded payments to a retailer conditional on the retailer exclusively selling computers containing Intel CPU. The Commission found that these practices constituted exclusivity rebates. Thirdly, Intel awarded 3 OEMs payments conditional on the OEMs canceling or postponing the AMD CPUs. These practices were found to harm competition and further reduce consumer choice and lower the incentive to innovate. Regardless of identifying an abuse under the traditional formalistic approach, the Commission also conducted an AEC test which showed that as an efficient competitor was not able to compete on the merits. What is particularly interesting to note here is that this was done despite the Commission believing that it was not necessary to conduct such tests since the rebates and payments were, by their nature, illegal. As you may recall, this is actually the opposite of what they set out in the guidance of 2009, where they came close to endorsing the test as necessary but not sufficient. The General Court upheld this Intel decision on all points of law and fact. The ECJ upheld Intel's appeal on the General Court's failure to assess Intel's rebates in light of all the relevant circumstances and pointed out that not every exclusionary effect is necessarily detrimental to competition, given that competition on the merits may be, by definition, led to the marginalization or exit of less efficient competitors. The ECJ also stated that even in the case of exclusivity rebates, if the undertaking concerned submits on the basis of supporting evidence that its conduct was not capable of restricting competition, the Commission is required to analyze all such evidence and arguments. Furthermore, the ECJ also concluded that the AEC test contained in the Intel decision played an important role, and that the General Court was required to examine all of Intel's arguments concerning that test. As such, the Intel case indicates that the AEC is one line of analysis that can be used to assess potential abuse. In view of this recent application of the AEC test in the EU, it is relevant to ask, how does the test fare in terms of meeting the objective of a unifying principle for exclusionary abuse? In other words, how does the AEC principle fare in terms of legal certainty and minimizing the occurrences of both false positives and false negatives? The most fundamental critique of the AEC test in terms of underdeterrence and false negative is that economic efficiency, as well as consumer welfare in some circumstances, also can benefit from the existence of less efficient competitors. This can be true in both a static sense and in a dynamic sense, where new rivals have the potential but need the time to reach sufficient efficiency. The Commission does acknowledge this in the notice, stating that in certain circumstances, a less efficient competitor may also exert a constraint which should be taken into account when considering whether particular price-based conduct leads to anti-competitive foreclosure. Careful consideration to what is meant by the concept as efficient and what costs are relevant in the specific case is of crucial importance. As an example, consider this. As the first mover, the dominant undertaking has often incurred entry costs, which are already sunk from the firm's perspective. In the interest of efficiency, it must be the case that such costs are not always included in what constitutes the costs of the as efficient competitor. In entries where the entry cost is of considerable size, such as in the network or software industries, it may be at times justified for competition enforcers who aim at enabling entry to include the incumbent's sunk costs in the as efficient competitor analysis. This is also partly acknowledged in the Commission's notice, where it is as stated that in situations where common costs are significant, they may have to be taken into account when assessing the ability to foreclose equally efficient competitors. Finally, we may ask ourselves, has the AEC provided more legal certainty? While the AEC test has been acknowledged and applied in practice, it is still connected with much uncertainty, which we've touched upon in this presentation. Firstly, which costs that are relevant, and secondly, the fact that it is only one tool among many to identify abusive exclusionary conduct constituting severe sources of legal uncertainty. All cases and guidelines referred to in this video are listed here. And as always, please feel free to reach out with any questions, comments, or concerns.